While delivering the final judgment today, Chief Justice Martha Koome said the president cannot initiate amendment through popular initiative as it is a preserve of the citizens and the basic structure is not applicable in Kenya. Let's revisit that report by Kennedy Kimani, who was present at the Supreme Court and filed for us the following report.
The many attempts to bring to life the Building Bridges initiative flopped completely on Thursday after the 7-judge bench of the Supreme Court declared the BBI bill as unconstitutional. The Attorney General Kihara Kariuki, the IEBC, and BBI co-principals Uhuru Kenyatta and Raila Odinga had filed an appeal at the A-pex court after the Court of Appeal threw out the BBI push last year. Before the A-pex court on Thursday, there were 7 pertinent issues that were framed for determination by the 7-judge bench, among the key issues being whether the president The many attempts to bring to life the Building Bridges initiative flopped completely on Thursday after the 7-judge bench of the Supreme Court declared the BBI bill as unconstitutional. The Attorney General Kihara Kariuki, the IEBC, and BBI co-principals Uhuru Kenyatta and Raila Odinga had filed an appeal at the A-pex court after the Court of Appeal threw out the BBI push last year. Before the A-pex court on Thursday, there were 7 pertinent issues that were framed for determination by the 7-judge bench, among the key issues being whether the president can initiate constitutional changes through a popular initiative. All the judges apart from Justice Njoki Ndung'u upheld the appellate court ruling that stated that the president cannot initiate a popular initiative as it is a preserve of the quote-unquote Wanjiko. According to Justice Ndung'u, the real initiators of the popular initiative were Dennis Waweru and Junet Mohammed, and not President Uhuru Kenyatta and Raila Odinga.
Number 2, the president is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution.
Clearly, in promoting and enhancing national unity, the President can promote constitutional amendments through popular initiative. This would qualify as a measure taken under Article 132 on which progress achieved can be reported.
Regarding the basic structure doctrine, Chief Justice Martha Koome said that the High Court and the Court of Appeal erred by creating the 4th pathway, which was tantamount to amending the Constitution through judgment of the court. CJ Martha Koome argued that the basic structure doctrine is not applicable in the country. Therefore, the 4 sequential steps are not necessary in order to amend the Kenyan Constitution.
The basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010.
The A-pex court judges also ruled that the second schedule in the BBI on the creation of the 70 new constituencies was unconstitutional due to lack of public participation. Chief Justice Martha Koome, who read out the final orders of the Supreme Court, noted that the basic structure doctrine is not applicable in Kenya. The president cannot initiate amendment through popular initiative. The creation of 70 constituencies is unconstitutional, and that civil proceedings cannot be initiated against the president. Also, the court ruled that there was inadequate public participation on the second schedule. IBC was quorate and competent to handle the BBI bill. The issue of multiple questions was not tried for determination, and each party should bear its own cost of suit. Out of the 7 contentious issues, CJ Martha Koome said that appeal will only be allowed on issues number 1, 4, 5, 6, 7, and will be disallowed on issues number 2 and 3.
It was not a popular initiative, it was not a people-initiated process, but it was one that had been conceptualized and put in place by President Uhuru Kenyatta and his brother Raila Amolo Odinga. The second reason is because the people of Kenya were not given an opportunity to actively participate in the initiation and the promotion of this enterprise.
So it is upon proponents of BBI and the political leadership that supported it to decide whether they want to bring it up now, whether they want to bring it up in its entirety. They might very well decide to go and even expand it. So it is up to them to now decide on what is going to be the way forward.
For now, it is the end of the road for the Building Bridges initiative, with the Supreme Court having declared it as unconstitutional. And with just less than 5 months to the August polls, the verdict by the Supreme Court is a big blow to the BBI proponents, as the reggae has now officially stopped. Kennedy Kimani, Hope TV Newswatch, at the Supreme Court buildings, Nairobi.